is an appeal in the matter of Lloyd's Insurance Company SA and Oceanus Capital SARL.
Mr. Bailey.
May it please the Court. I appear for the appellant in this case, together with my learned junior, Miss Emma Franklin. My learned friends, Mr. Nick Vinial and Mr. Neil Dowers, appear on behalf of the respondent. And as the Court will be aware, this is an appeal that's brought with the permission of the learned Deputy Judge against her order dated the 17th of December 2025, whereby she found that the respondent was entitled to an indemnity under a mortgagee's interest insurance policy that was underwritten by my clients. And you'll be able to find a copy of the order at tab 7 of the core bundle, and the grounds of appeal are at tab 2 of the core bundle. We don't need to turn them up, but that's where they are to be found. Now, in addition to the core bundle, the Court should also have a supplemental bundle consisting, I think, of 39 tabs. And in addition to that, there should be 2 bundles of authorities, which I hope you've all received. In terms of housekeeping, your Lordship should have received 2 additional authorities and a revised index, and I hope they may have found their way into to the desk.
These are they. Indeed.
Well, I'm much obliged. The index, I think, could simply go into the bundle of authorities. The additions, the first is the latest version of Colin Vaughan Merkin, which is a loose leaf publication which has been updated to take account of the first instance decision in this case. And the relevant paragraph is paragraph B-0804. And if you were to compare and contrast that with the previous version, which is in bundle 2 of the bundle of authorities, page 681, you will see that what the editors have done to take account of the decision at first instance in this case is to delete what was the second sentence of paragraph 0804, which said that the interest is the right to claim under the owner's marine or war risk policy as the case may be, its capacity as assignee or loss payee for loss or damage to the mortgage vessel. That's been deleted, and in its place is the new paragraph, which you'll see begins with the words, a mortgagee has, under section 14, an insurable interest, and then the editors refer to the dispute about whether or not the interest insured is the mortgagee's right to claim under the policy, or its proprietary interest in the vessel and loss and damage to the vessel. They make the point that maybe it doesn't make any difference, and there is a footnote also added at footnote 3, which was not there before. So those are the changes that the editors made in light of the decision below. That's the first bit of housekeeping. The second is that in the clip that you've been provided with, hopefully there is a copy of a decision of Mr. Justice Carr, as he then was, in a case called the Michael,
Yes.
Which is reported in 1979, volume 1 of the Lloyd's Law Reports at page 55. It's a relatively lengthy decision and concerns an alleged scuttler. The reason I provided it to you, Lordships, is really because of one particular paragraph or passage, which is to be found at page 66. On the bottom of the left-hand column of page 66, the learned judge says, by reference to the definition of barratry, the comments on this term in the textbook show that, quote, the prejudice of the owner means in effect without his consent, or to use an expression which is sometimes used in other contexts, without his privity. See section 39.5 of the Marine Insurance Act in the context of sending a ship to sea in an unseaworthy state. It is clear that consent or privity can range from active complicity to mere passive concurrence. An owner who makes it clear that he would like to see his ship at the bottom of the sea, but does not want to know any more about it, is privy to its sinking in just the same way as Henry II was privy to the murder of Thomas à Becket when he said, "Will no one rid me of this turbulent priest?" Even if the suggestion of scuttling comes from someone else, and the owner implies consent by saying nothing against it, he would be privy and could not say that the act was to his prejudice. That, we would submit, is going to be helpful when we come on to the second ground of appeal, and I have to say, we only found it recently, and for that reason, sadly, I wasn't able to show that authority to the learned judge below, but nonetheless, we submit it will be an assistance.
I remember that Michael in the Court of Appeal was one of the first cases I ever attended as a pupil, but presumably there's nothing in the Court of Appeal judgment which adds or subtracts from Thomas à Becket.
No, that's right, my lord, yes. Now, the core bundle, which you have, obviously contains the party skeleton arguments, the judgment below is at tab 8, and the relevant policy, which is the MII policy, if I may call it that. What I mean by that is the mortgagee's interest insurance policy, but I'll refer to it, if I may, as the MII policy, is at tab 13. In terms of references, I propose to refer to what is the underlying primary annual war risk policy as the war risk policy, or words to that effect, to be contrasted with what's been described as the additional December cover, or the DAC, the December additional cover, which is the policy which was ultimately found to be forged and didn't respond to the loss. So I'll refer to that, if I may, as the DAC, or the December additional cover.
Perhaps more accurately, December additional cover note.
Well, yes.
Not constituting cover at all.
Well,
but that's to get ahead.
Well, we'll come on to that, but yes, that's what I'm referring to, that document at least.
Yeah.
And just by way of introduction, it's a very small point, but could I take you, please, to the MII policy, which is in the core bundle at tab 13. And in particular, if I could take you to page 159. At the very top of the page, you'll see next to the bold words conditions, it says wording, institute mortgagee's interest clauses holes, and then it has in brackets 1379. Now, just pausing there, that actually is a typo. It should actually say 1397. And we can see that actually from, if you turn forward in the same bundle to page 169. You'll see at the end of the wording, it actually says correctly 1397 and the CL 33797. So it's basically, and this is common ground, just that I wanted to correct the typo. This is in fact a policy written on the latest and current standard market wording, which is the 1997 Institute Mortgagee's Interest Clauses Holes. There was a previous version in 1986, but that didn't gain much traction. And the wording we would submit of this latest form of MII policy is different, and in some respects markedly different from the wording of MII policies which have been the subject of previous decisions. The consequence of that is that this is the first case where the court has been called upon to construe the insuring clause within this policy wording, and the previous decisions are unlikely to be of any assistance to the court in determining what this particular policy means. Now, by way of introduction, just to show your lordships where the relevant language is to be found at page 163 of the bundle. And the key language which requires to be construed, appears under paragraph 1, the insuring clause. In particular, paragraph 1.1, and then the indemnity provision in paragraph 1.2, which refers to net loss, and there's a definition of net loss which you can find at page 165, paragraph 2.3. Now, I'll be making detailed submissions on the proper construction of those paragraphs, but that's what I wanted to say by way of introduction. Now, as the court will have seen from the skeleton arguments, there are effectively 3 grounds of appeal. And in terms of the shape of my oral submissions, what I propose to do is to address them in turn, starting first with the causation issue, then dealing with the privity issue, if I may call it that, and then finally the fortuity issue. Your Lordships may have seen from the skeleton arguments that there was a debate between my learned friends about whether one of the points we'd taken, namely a prima facie covered point, was open to my clients in this court. And we provided a supplemental skeleton argument. I don't know if we've had a chance to read it. And my learned friend has very kindly indicated to me that he no longer suggests that the point isn't open to us.
Yeah, thank you very much.
So I hope that assists.
It does.
So against all that background, if I may then turn to the substance of the case, and in particular start with the appeal in relation to the causation issue. Now, the judgment, which you will know is at the core bundle, tab 8, dealt with my client's causation defence at paragraphs 26, page 89, and then again at paragraphs 28, begins at page 90 to 52, page 104 of her judgment. Perhaps we could go to the judgment itself and start, if we may, at paragraph 26, where the learned judge effectively summarised my client's case on causation, namely that the insurer's defence to Oceanus's claim, put simply, is that as a matter of common sense and legal analysis, the proximate cause of Oceanus's loss is the invalidity or nullity of the December additional cover that was supposed to provide prima facie cover for loss of or damage to the vessel whilst in Ukrainian waters in December. It was the fact that this cover did not respond on account of its forgery, which was the effective and proximate cause of Oceanus's loss. That forgery and the consequential non-payment was not a risk assumed by the insurers. It's not an insured peril, and therefore not a loss covered by the policy. And that's an accurate summation of our case. And in particular, she then summarised it in even greater detail between paragraphs 36, which begins at page 95, through to paragraph 43 at page 100. If I could just, in the sense that it saves me having to articulate them again, and it's put in a comprehensive fashion, highlight a number of passages from that section of the judgment. Starting, if I may, at paragraph 36, and the particular point I want to highlight is that begins at the last sentence on page 95. The MII policy is not a primary insurance on property, nor a form of fidelity insurance providing Oceanus as mortgagee against the generic risk of dishonesty on the part of owners or charterers. In particular, the MII policy does not respond where the proximate cause of Oceanus's loss is the invalidity or nullity of the primary policy that is supposed to provide prima facie cover for the loss of or damage to the vessel, namely the DAC. The MII policy is a contingent and secondary form of insurance that insures Oceanus against financial loss as a result of the primary insurance cover not responding to a claim for loss or damage to the vessel caused by certain defined conduct on the part of Lyra Mare, specified as insured perils. And then at paragraph 37 at the bottom, our case, it was and is, 6 lines up from the bottom, the relevant loss insured against by the MII policy being the first reference to loss in the first line of the insuring clause, clause 1, is Oceanus's net loss, which results from loss or damage to the vessel, which is prima facie covered by the insurance primary policies, coupled with non-payment under the relevant Lyra Mare Policy caused by an insured peril. Oceanus' net loss resulting from non-payment must be proximately caused by a named insured peril as defined by clause 2.1. And then at paragraph 39, the same point is picked up from the third line. In the present instance, the relevant loss is the financial loss that is caused by reason of the December additional cover not responding. And the relevant risk that is being insured against is the risk of financial loss due to non-payment by Lyra Mare's underwriters as a result of one of the specified perils in the MII policy. And at paragraph 40, and this picks up the point my Lord Justice Popplewell made a moment or two ago about the fact that the December additional policy was invalid. 4 lines in, she says, Mr. Bailey KC contended that the question ignored what actually happened in the present instance. What actually happened is that the December additional cover was sought and was a real document which had real causal impact. Now, I'll come on and develop that in more detail, but that's an important part of our case. And then in paragraph 41, there are some very familiar submissions in relation to what is meant by proximate cause and references to the key underlying authorities. Perhaps one should add to that the FCA case where Lord Hamlin, Lord Leggett, referred to those 2 cases and said, although common sense is clearly important, it's not just a gut reaction, it requires some form of analysis, which I'm going to try and endeavour to give your lordships as to what is and how you identify the proximate cause. In paragraph 41, 7 lines from the bottom, Oceanus' argument on proximate cause, namely that the December additional cover could not be the proximate cause as the cover did not in fact exist, is not only inconsistent with commercial common sense, it fails properly to appreciate that the relevant causal nexus is whether the proximate cause of Oceanus' net loss as a result of non-payment was an insured peril under clause 2.1. And then paragraph 42, taking a step back and looking at the circumstances of the trading into Ukrainian waters, the mine strike and the position in which Oceanus found itself, if one were to ask what caused Oceanus' loss, the common sense answer would be that the fact that Oceanus was duped into relying upon the December additional cover, which turned out to be a forged document. This is so because even if there had been a breach of trading warranties, and even if the vessel had been lost as a result of a mine strike, if the December additional cover had been valid, then the insurance recoveries under the December additional cover would have exceeded the balance owing under the facility, and Oceanus would have suffered no insured loss, and no claim would have been made under the MII policy. Now again, for the purpose of the causation analysis, we would submit that's the key point, and indeed the proper counterfactual that the learned judge should have had regard to when conducting her analysis of the causation issue. It goes on, it was the fact that the December additional cover did not respond on account of it being a forgery, which was the effective and proximate cause of Oceanus' loss. Whilst damage to the vessel resulting from the mine strike was operating in the background and was a necessary but insufficient occurrence to trigger the MII policy, it was the fact that the December additional cover did not pay out because it was a forgery that in fact caused the loss Oceanus has sustained. And then 5 lines down, she makes the point, it is only because Oceanus was unable to recover under the December additional cover that it has suffered a loss at all. And then she makes the point or rather she repeats the point that we made, that had the December additional cover been a valid contract of insurance but had been terminated for non-payment of premium before the mine strike, Oceanus' claim would have been excluded by the terms of the MII policy. It would be impossible in such a scenario for Oceanus to circumvent that exclusion on the basis that its loss was in fact caused by the failure of the war risk policy to respond as a result of the breach of the trading warranties. And then finally, paragraph 43 on page 100. Accordingly, as a matter of common sense and correct legal analysis, the proximate cause of Oceanus' loss was the fact that the December additional cover was invalid and did not pay an indemnity on account of the fact that it had been forged. Now, those essentially, she sets them out very comprehensively. That is essentially our case, and was our case before the learned deputy judge, and it's our case before this court. But as your lordships know, the learned judge rejected those submissions, and she sets out her own decision on proximate cause at paragraphs 44 to 52 of the judgment. And if I may, I'd obviously like to take your lordships to those paragraphs, and in particular, paragraph 44. Paragraph 44, she says, I consider that the proximate cause of Oceanus' loss was the loss of or damage to the vessel as a result of the mine strike. Now, in our respectful submission, that is the first fundamental error in the learned judge's analysis. And that error was repeated in the penultimate sentence of paragraph 52. You go to paragraph 52 on page 104. The penultimate sentence, she says, as stated above, in my view, it is clear on the wording of the MII policy that the loss insured is the loss of damage to the vessel. And the proximate cause of that loss is whatever damaged the vessel, here the mine strike. And you will know, but I mention it now because it's relevant later in the argument, paragraph 82 in the context of the fortuity issue, just convenient to take your lordships to it now, page 117 of the court bundle, paragraph 82, the reason and basis on which she rejected the fortuity defence was the same flawed construction of the policy, and you'll see that from the second sentence. The court has concluded that loss that Oceanus has suffered as assured has resulted from the loss of the mortgaged vessel by reason of the mine strike. And she obviously makes the point, which we don't dissent from, that the mine strike itself was plainly fortuitous. That's clearly right, but the error is the fact that she had wrongly identified in our respectful submission what the relevant insured loss is. So the first fundamental error in our submission is the flawed construction of the policy. And there are two key points, if I may, that I want to make in support of that submission. And to do that, it's convenient if we may look again at the mortgagee's insurance policy, which is at tab 13 of the core bundle. And in particular, page 163, clause 1, which is the insuring clause. And the paragraph 1.1 is the central and key provision, but also the rest of paragraph 1 is clearly relevant because it all forms part of the insuring clause, and the definitions, which you find at page 165, are also relevant when understanding what the insuring clause means. The error that the learned judge made in relation to proximate cause was the consequence of her flawed construction of the insuring clause itself in our respectful submission. In particular, the learned judge failed to understand that the MII policy is not a first-party property insurance whereby my clients promised to prevent or to hold the assured harmless against loss of or damage to the property. There was no promise on my client's part to prevent the vessel from sustaining physical damage. Rather, there was a promise on my client's behalf to indemnify the insured against loss, which resulted from two contingencies, one of which was damage which was prima facie covered by an underlying primary policy, and secondly, an essential part of the promise, if that policy does not respond as a result of an insured peril. Secondly, she failed to understand that the loss insured against is Oceanus's financial loss, as in the amount of the loan, effectively, that remains outstanding as a result of the failure of the owner's policies to respond to the casualty. And in my respectful submission, when clause 1.1 and 1.2 are read together, it's perfectly clear that the first reference to loss in paragraph 1.1, where it says this insurance will indemnify the assured for loss, that reference to the word loss there, although it goes on to say resulting from loss of or damage to the vessel, the first reference to loss in line 1.1 is the assured's financial loss in the amount of its net loss as defined, or the unrecoverable amount under the underlying contract of insurance. And that's clear from the syntax and language of clause 1.1 itself, but it's made doubly clear, in my respectful submission, from clause 1.2, which refers to the indemnity that's payable as being the amount of the net loss calculated by reference to the definition, which, as you'll see on page 165, means, this is paragraph 2.3, which means the assured's loss under the loan agreement, to the extent secured by the mortgage, net of any proceeds recovered or recoverable under all security arrangements contained in or collateral to the loan, including but not limited to all mortgages, liens, any floating and fixed charges, security interests, guarantees, insurance policies, and pledges. So all insurance policies, and this could be relevant in due course to the significance of the DAC, all insurance recoveries, all collateral recoveries are taken into account for the purpose of determining the net loss, because it's a financial amount which is being insured against by the policy, not a proprietary interest in the hull itself. And in our respectful submission, had the learned deputy judge construed the MII policy correctly, she would have understood that the policy is essentially a secondary, or one might call it a contingent insurance. That only.
But pausing there, we haven't got on to 1.2.2, the unrecoverable element. But you were just focusing on 1.2.1 and the definition of net loss.
Yes.
And all mortgagees' interest policies, which are in that form, that is to say, insuring against the irrecoverability of the loan, aren't they insurances on the vessel? Because it's the security interest in the vessel which gives the insurable interest, and it's the ability to realise that security against the vessel which impacts on the recoverability of the loan.
Well, my lord, if I may respectfully say so, no. And the reason I'm saying no is because it's not the irrecoverability of the loan that represents the loss. It's the fact that there's been non-recovery under the primary policies,
Well,
which has
I
meant...
quite understand that. That's why I said we haven't got to 1.2.2 yet.
Yes.
But leave aside the contingency of irrecoverability under the policies, which I quite understand you say is an important element.
Yes.
But if you put that to one side, would the insurable interest not be the interest in the loss or damage to the vessel?
There is obviously an insurable interest in the vessel.
Yep.
We know that. The question is, what interest is being insured by clause 1.
Yep.
And we know also that there's an insured interest as loss payee in the insurance policies. And in my respectful submission, the loss that's being insured against under clause 1 is the loss that results from the non-payment of the primary insurances. And it's not the your Lordship characterises the irrecoverability of the loan. There's not an irrecoverability of the loan, just the amount of the loan outstanding. What would happen is that my clients, if we paid out under this policy, would be subrogated to the rights to claim under the loan agreement against the debtor. And that loan actually may be perfectly recoverable if they're solvent. The key point, I think, my Lord, if I may say so, is that there's no requirement on the part of the mortgagee to sue the borrower to judgment. It's the net loss is the amount outstanding, or the extent of the loan that's outstanding, net of those that are recoverable from the various securities, and including in particular the insurance policies. There's no requirement on the part of the mortgagee to go off and sue the borrower in order to determine their net loss. It's not because the loan is unpaid by the borrower that there is a claim under the insurance policy. This policy, the purpose of this policy, shortcuts that. The whole purpose is that as soon as there is an unrecoverability under the primary security, namely the underlying insurance policies, meaning that the loan is outstanding and not repaid, the mortgagee can claim an indemnity from my clients, saving it having to go off and sue the borrower. And my clients are left with that subrogated claim if we wish to pursue it, to try and recover the amount we paid out.
And that's rather unrealistic, isn't it? To think that there would be a valuable subrogated claim against what is likely to be, in most typical situations, a one-ship company which has lost its ship, where the war risks policy is not going to pay.
Well, quite. It may well be that the subrogated claim over is of no value, and therefore my clients end up carrying the can. But the key point here, though, is what is the loss that is being insured against by my clients that is sustained by the mortgagee? And the loss that's being insured against is that arises by reason of the fact that it doesn't recover under the primary policies. And because it doesn't recover under the primary policies, it has an outstanding loan. Or rather, that amounts to that's how you quantify its loss. But it's the non-recoverability of the underlying primary policies which amounts to the risk, essentially, that is being insured against. I mean, perhaps that's another way of putting it. What is the risk that is being insured against or being assumed by my clients? And the risk that's being assumed, we would respectfully submit, is that the primary policies do not respond to the loss, the casualty.
I suppose the other way of looking at this rather long and tangled sentence is to say that what's insured against is certain kinds of physical loss to the vessel, namely those which are prima facie insured, but for which the insurers don't pay for various identified reasons, occurring without the privity of the assured. So instead of having, it's insurance against the loss of the vessel, which means that they have nothing to enforce.
Well, my Lord, if I may say so, that's wrong, because it's verging very much towards the construction the learned judge adopted, which is that the interest being insured is proprietary interest in the vessel. But there's no promise on the part of my clients to hold mortgagee harmless against damage to the vessel. And the key point, perhaps this is the easiest way of unlocking this, is to look at the insured perils. In a property insurance, the perils that are being insured against would be those that cause damage to the property. All the perils that are referred to in this named peril policy, the perils that relate to the reason why the primary policy does not respond. All of them. So if you look at the insured perils at paragraph 2.1, First is avoidance of the underlying policies. 2.2 is breach of a statutory provision or warranty. 2.1.3 is failure to exercise due diligence. 2.14 is the deliberate casting away. 2.15 avoidance of the claim. 2.16 a limitation that prevents the claim being presented in time. And 2.17 is the failure to be able to demonstrate that there was a loss caused by perils of the sea. Now, all of those perils, all of the perils that are identified, which of course must be the proximate cause of the loss, relate to the non-recoverability under the primary policy. None of those perils can be described as capable of causing physical damage to the vessel. And that's the key way, I think, of unlocking why, when construing clause 1.1, it's clear that it's not a primary or first party insurance against proprietary damage. It isn't. It's an insurance against the unrecoverability under the primary policies in relation to the casualty that is caused by an insured peril. And the insured perils all relate to the reasons why the policy doesn't respond. None of the perils could possibly be said to be relevant to the cause of damage to the vessel. And that's because the property interest is not the interest that's being insured against, nor is it the loss that's being insured against. The loss which the insured perils relate to is the unrecoverability under the primary policies. and another curious aspect of the learned judge's conclusion on proximate cause, namely that the proximate cause of the loss was the damage, physical damage to the vessel caused by the mine strike, is that finding doesn't actually assist the respondent here. And the reason it doesn't assist the respondent in the context of a named peril policy such as this is because that cause is not a named peril. The mine strike or physical damage to the vessel is not a named peril. It's not within the scope of the perils. And that's crucial because it's clear from Section 55 of the Marine Insurance Act, and it's a matter of common sense, that my clients are only liable for losses that are proximately caused by a named peril.
What about the wording in the beginning of 1.1? Loss resulting from loss of or damage to the vessel.
Which?
Does resulting from not also have a proximate cause?
Well,
I understand you focus on the insured perils in 2.1, which, as you rightly say, all relate to the irrecoverability of the claim under the owner's policy.
yes.
But to say that it can't be an insurance of property because there's no requirement of proximate cause between between mortgagee's loss and loss or damage to the vessel, does that take account of the wording at the beginning of 1.1?
Well,
It has to be loss resulting from loss of or damage to the vessel.
My lord, it does, because clearly there has to be a causal connection between the loss and which results from damage. But the key points here are twofold. Firstly, the fact you have to read the word which in there. So it's loss of or damage to the vessel which would prima facie be covered and in relation to which there's a subsequent non-payment by any of the underwriters as a result of any insured peril. So you don't stop, as the learned judge seems to have done, and put a full stop after vessel and ignore the word which. Everything that follows after the word mortgage vessel, including the word which, qualify what is meant by the damage to the mortgage vessel. That's the casualty. The casualty has to have been covered by or prima facie covered by the insurance policy. There is a non-payment by reason of an insured peril. That's the first answer. The second answer, my lord, is this, that clearly there is a causal requirement in the fact that the loss the financial loss must be caused by or result from a casualty which is not covered. But the casualty, i.e. the damage to the vessel, is not caused in any proximate sense by an insured peril. The question of proximate cause only relates to the relationship between the insured loss and the insured peril. That's what Section 55, perhaps we should look at Section 55 of the Marine Insurance Act. I think it's in Bundle 1, Tab 1.
But I think what I'm putting to you is that it could be said it is a peril, that the vessel is lost or damaged.
Well, my lord, absolutely not.
Because
It's not identified as such within the perils clause. There's a specific named perils clause here, clause 2.1. They are the insured perils. They're specifically identified.
Well,
it's not an all risks.
Perils, but
it's not an all risks policy.
If the opening words require there to be a loss resulting from, read approximately caused by, because that's how we construe resulting from, a loss approximately caused by loss of or damage to the vessel. Why is loss or damage to the vessel not a necessary peril? Like, quite accept it's not the only peril. There is, whether you call it a contingency or whether, as you would characterise it, the other perils are the important perils. But I'm just wondering why you say loss of or damage to the vessel isn't a peril.
Well, it's crucial it's not a peril, because the relationship between peril and loss is the key relationship which defines the existence of cover. And here we have loss defined, which we're debating, and we have a series of specific perils. And in order to recover under this policy, one has to prove, as Section 55 of the Marine Insurance Act makes clear, that the insured loss was caused by a named peril. Now, that doesn't mean that actually probably is less between us now, my lord, than there was a moment or two ago, because I agree with you that it's a necessary precondition to recovery under this policy, or an element of the trigger, if you like, that the loss must have resulted from a casualty to the vessel. That is a necessary precondition. It's one of the contingencies. So there has to be damage to the vessel. But that in itself doesn't trigger any response on the part of my clients. There's no obligation to pay simply because there is damage to the vessel. There's only an obligation to pay on the part of my clients if there is damage to the vessel which is prima facie covered and in respect of which there's no payment by the primary policy. You have to have both of those contingencies satisfied before there can be a recovery under the policy.
And does the first of those have to be causative of loss? Or do you say not?
Well, by definition,
loss or damage to the vessel?
Well, by definition, no, it doesn't have to be causative. It will be causative.
Well, it may not. Suppose, I mean, take a hypothetical case in which there's loss or damage to the vessel, but the vessel is completely worthless.
Yes. Well, then there would be no loss within the meaning of the very first word, loss.
Right, because it is a causative requirement that loss has been caused by loss or damage to the vessel before you get to the other causative requirements, I think, on your case.
My lord, that's right. I mean, as I say, I've always accepted, and plainly it's right, that there is a necessary contingency built into clause 1.1.
Well, it's not just a contingency. There has to be a causative element between that contingency and the loss. Is what I'm putting to you.
Well, the word result.
Of course, yes. I quite understand you say in most cases there will be,
yeah.
But
theoretically you're right, my lord. Yes,
yeah.
It's
so,
perfectly possible.
And that's why I say that might probably be characterised as a peril, which must be approximately causative of the loss. Not sufficient in itself, but yeah. Nevertheless.
Can I try and obviously this is an important point of the way in which your lordships have articulated it. If we agree that there is a causative requirement that arises out of the words resulting from, so you get assured for loss resulting from loss of or damage to the vessel, that does impute a causative requirement. Perfectly accept that. My key point is that the relevant causal connection that triggers the policy to respond is that the loss must have been caused by, proximately caused by, one of the named perils.
Can I just follow that up a moment? You mentioned Section 55, and that says that an insurer is liable for any loss approximately caused by a peril insured against.
Yes.
And you point out that here there is a list of insured perils.
Yes.
But presumably, the use of the word insured perils isn't of itself necessarily determinative. You could have a peril insured against, regardless of whether it was listed as an insured peril in quite that sense.
Well, my lord, no, with my respectful submission. The insured perils comprehensively set out what the insured perils are.
So on that thesis, if one, as a matter of categorization in another way, thought to oneself when an insured peril is loss to the vessel, damage to the vessel of a particular kind, that would be incapable of being a peril insured against because it wasn't one of the insured perils listed.
My lord, no. It could be a peril insured against, but that would be a classic first-party property insurance policy, whereby what is happening is the insured, it could be the mortgagee because he has an insurable interest in the hull, could take out a property policy on the hull. And the promise would be, by the insurer, to hold the mortgagee harmless against the physical damage or loss of the vessel. And as soon as that damage occurred, the policy would be triggered, wouldn't even need to be a claim, there'd be a liability. That's what a first-party property policy does. In my respectful submission, that is fundamentally different from this policy. It doesn't respond to or cover or hold harmless against property damage. Now, property damage has to be a cause of the loss, but that is part of the, I would say, part of the two contingencies which are necessary to trigger the liability of my clients. Those two contingencies being loss resulting from the casualty and, or which, perhaps this is not just and, which is prima facie covered, but in respect to which the policy doesn't respond because of a named peril. And that it's the linkage between the named perils and the non-response of the underlying policy, which is the key causal requirement, which has to satisfy the proximate cause analysis for the purpose of recovery.
I entirely understand your submissions. And one of the things the judge said was she wasn't sure that it mattered, although she said, I accept Mr. Vinyl's submissions that the proximate cause is the mine strike. She said actually what matters is whether the policy conditions are fulfilled. And one can have cases where, as so often in life, there are a series of causes, each builds on the previous one, and you have to decide what a proximate cause is. And sometimes you have multiple insured perils. I mean, I have in mind some of the litigation in relation to COVID cover, in which you had area clauses and so on, in which there was more than one insured peril, and you had to show that the second insured peril was proximately caused by the first, and the first insured, the loss was proximately caused by the first insured peril. And as we know, you can have a proximate cause of loss, not just one proximate cause of loss, and the COVID cases were quite a good example of how that arose.
Quite.
So it is one way of looking at this. You've got two sequential insured perils in a sequence. First of all, there must be loss of or damage to the vessel. And then...
I don't accept that's an insured peril, but yes, I accept it's a requirement, I guess.
It's a requirement, right. And then you have to show that the loss which results from that is also caused by the non-responsiveness of the owner's policies as a result of one of the insured perils in clause 2.1.
Well, no, not the loss.
Is that a way of looking at it? Or?
I would respectfully say not. It's not the loss that follows from the physical damage. It's the financial loss that arises because of the fact there is a casualty and, crucially, the non-response to the underlying policy as a result of an insured peril. And it's why, if I may say so, your analysis overcomplicates matters is because what's clear, in fact, it's easy to look at it this way, is that when you look at all the named perils, and it's a named peril policy, it's not an all-risk policy, it's a named perils policy. When you look at the named perils, they all relate to, or can only be said to relate to, the reason that the primary policy doesn't respond to the casualty. That's the crucial nexus, causal nexus, that triggers response to this policy. The learned judge was just completely wrong to start regarding the question of proximate cause in relation to property damage as being the relevant causal nexus for the purpose of recovery. It was clearly there had to be a casualty to the vessel. And by definition, subject to the point we debated earlier, whereby the vessel's worth nothing, by definition one would expect ordinarily that to cause loss. But the relevant loss in this case is not the impairment of the interest in the physical property. It's the financial loss that results from the fact that given the given the vessels being compromised physically, the primary policy which should have paid failed to do so. And as a result of that failure to pay out, there is a loss. It's not dissimilar in a sense to the lessor's policies in the Russian aircraft cases, which were essentially contingent.
Might it also be said that it's the casualty that, to a vessel said to be worth 5 million plus that has led to the mortgagee not being able to realise that security, but for which there wouldn't be a net loss. That's to say, anything outstanding on the loan. I mean, I quite understand that you focus on it being a requirement, that there's been an onerous policy that's not responded as a result of one of the insured perils, but I'm just not sure how much help I'm getting out of focusing only on that aspect and not focusing on the fact that the loss or damage to the vessel is something that has to occur, and but for which there wouldn't be the net loss, which is the irrecoverability of the loan.
Well, Lord, again, it's not the irrecoverability of the loan. That's the second time your Lordship said that.
Yeah.
And it's not the irrecoverability of the loan. It's the net loss is the amount of the outstanding loan agreement, net of any recoveries under the collateral security.
Yes, but as I say, in a normal mortgagee's policy, if we didn't have anything to do with irrecoverability under war risks, that might very well be the measure of net loss. That is to say, the amount outstanding under the loan. But that wouldn't stop it being an insurance on the mortgagee's interest in the vessel, which was where I started this.
Well, the purpose of the mortgage MII policy is essentially to stand behind the primary policies, which, had they responded, would have repaid the loan.
Right. I have that submission, and if that's right, then that's.
Well, that I think goes some of the way. I don't want to leave this debate with the hanging without articulating with some clarity our case on it, because clearly it's important to your Lordship's consideration. And I just want to reiterate that I do not say that it's unnecessary for there to be a loss as a result of physical damage to the vessel. Clearly there has to be loss of or damage to the vessel as a prerequisite to the insured sustaining any loss at all. And I accept that arises from the words, this insurance will indemnify the insured for loss resulting from loss of or damage to the vessel. Obviously, however, it's not an insurance that indemnifies the assured for loss of or damage to the vessel. It's the loss which results from that damage, which would prima facie be covered, but in relation to which there's non-payment because of an insured peril. So unless the physical occurrence of damage was covered by a primary policy which didn't pay out because of an insured peril, there would be no recoverable insured loss, even though the vessel had been damaged.
And vice versa.
And vice
I'm putting to you.
I hope that's a more comprehensive way of putting it. The two key points on which I rely are the fact that this is not a policy that insures against property damage. The mortgagee can't come along to my clients and simply say, "Oh, my vessel's been physically damaged. You promised it wouldn't happen. Give me some money." That's not how this policy operates. It requires these two contingencies to have occurred. And the second key aspect is it is not an all-risk policy. It's a named perils policy. It identifies all the relevant perils in paragraph 2.1. And in answer to my learned friend, my Lord Justice Newey's point, all those perils are specified, and you can't infer, in my respectful submission, the existence of additional perils outside the scope of the insured perils clause. So anyway, my Lord, those are my main submissions on construction as to why, when the learned judge said that the proximate cause for the purpose of recovery under this policy of the loss was the damage to the vessel, is simply flawed, but more importantly, it's inadequate. And the reason it's inadequate is, and doesn't assist the respondent, is because in a named perils policy such as this, it is necessary, in order to recover, to demonstrate that the proximate cause of loss is the named peril, one of the named perils. Unless that is established, then there is no liability given Section 55. So it was essential, if my learned friends were to recover, that they had to persuade the learned judge below that the proximate cause of their loss was one of the perils identified in clause 2.1 of policy. And those perils do not include physical damage to the vessel as a result of mine strike or any other cause of physical damage. So, with the greatest respect, that we would submit is the first fundamental error the learned judge made on causation. The second fundamental error in the judge's analysis we would submit is in paragraph 47 of her judgment, which is tab 8, page 101. Where she says, "I agree with Mr. Vinial that the December additional cover purported to be evidenced by a forged cover note never existed and cannot be treated as part of the owner's policies for the purpose of clause 1.1. A forged policy is not akin to a valid policy which has subsequently been cancelled, for example for non-payment, or one which was caused to be entered into by misrepresentation. A forged policy does not exist as a matter of fact." Now, we respectfully submit that that's wrong, at least in terms of its relevance to the causal inquiry. And I've got 4 points, if I may, in support of that submission. First point is this, that the fact that a forged document is invalid as a matter of law does not mean that it did not exist as a matter of fact, or that it can have no causal consequences. The true position in our submission is that the DAC was a real document that Oceanus approved in writing and on which Oceanus relied as the policy providing it with prima facie cover for war risks while the vessel was in Ukrainian waters. The second point is that the judge's approach mirrors a point that was made by my learned friend below, and indeed is repeated in their skeleton argument for this appeal, and it's in paragraph 41 of their skeleton, which is at page 56 of the core bundle. Where my own friends say, but neither formulation of Oceanus' claim is based on the loss of or an indemnity under the non-existent December additional cover. Indeed, it is difficult to see how a non-existent policy of insurance could possibly have caused loss to Oceanus or to anyone. Now, even if it's right to characterise a forged policy as being non-existent in a legal sense, it is easy to see how such a policy could cause loss. Now, there's a very straightforward example. For example, imagine that a wife who pays a rogue broker £10 for a £100 policy, a life policy, on her spouse. Take that as an example. Now, if the husband dies and the policy turns out to be a forgery, it's obvious in my respectful submission that the non-existent or the forged policy will have caused the wife a loss in the sum of £100, not just the £10 that she paid for this fraudulent broker for a non-existent forged policy, but her loss would be £100, namely that which she would have expected to recover under the forged policy. In my respectful submission, it's no different to counterfeit money or to a forged bill of exchange or a forged letter of credit. The essential point being this, that if anybody supplies goods or services in return for a counterfeit financial instrument, they will suffer a real loss as a consequence. So in my respectful submission, it's wrong, at least from a causal sense. I'll seek to explain why. But wrong in a causal sense, which essentially is a factual inquiry, to say that simply because the DAC was a forged document, that it is to be treated as if it never existed for the purpose of the causal inquiry. That, we would respectfully submit, is wrong. The third point is this. Now, given that it was a forgery, the judge below held that the DAC could not properly be regarded as one of the owner's policies within the meaning of clause 1.1. Now, we say she was wrong about that because ostensibly, at least, it was a policy which prima facie, by which I mean subject to the point of it being a forgery, prima facie did provide cover while the vessel was trading in Ukraine.
But it wasn't a policy.
Right.
If we go to the wording of the clause, prima facie covered by owners' policies and club entries, as defined. I quite understand your point that a forged document, that has a document, can be causative of loss.
Yes.
But is a forged document which is not a policy capable of being an owner's policy or club entry? Because unless it is, we don't get into whether or not it prima facie provides cover, do we?
Well, I think...
But we're concerned with prima facie cover, not prima facie policies. Perhaps that's another way of putting it.
My Lord, I think, if I may say so, I think your Lordship's right. And unlike the position I adopted on previous questions, your Lordship's right about that. All I can say in response is two things. Firstly, we do submit that a policy which, on the face of it, ostensibly provides prima facie cover is sufficient to constitute an owner's policy. That's my primary point.
But a document or a policy?
A document which purports ostensibly to be a policy. But that's my primary point. I say primary because it comes first in time. Now, my main submission is this, that this doesn't matter. It doesn't matter for the purpose of the causal analysis. And the reason it doesn't matter, whether it's an owner's policy within the meaning of clause 1.1 or not, is because for the purpose of the causation inquiry, if the DAC had not been forged and had responded to the casualty, then the owners would have suffered no loss, no insured loss within the meaning of clause 1.1 of the policy. There'd be no claim under the MII because the recovery under the DAC would have meant that there was no outstanding financial loss sustained by the lender, Oceanus. And this is not quite common ground, but it's almost common ground if one were to look at what my own friends say in their skeleton argument on this at paragraph 34, page 52. Paragraph 34, my own friends say, had the DAC cover been genuine, the vessel would still have hit the mine. Clearly that's right. Oceanus would still have lost its security, and Lyra Mare's original insurance still would not have paid out because of the breach of warranty. But Lyra Mare could have claimed under the DAC. Oceanus would have been entitled to that money, and as a result, Oceanus would not have needed to claim under the MII policy. Now, I don't accept precisely how that's characterised, but it's entirely correct to say that had the DAC responded because it was a genuine document, and as a result of the loss payee clause, the money would have gone to the mortgagee, the consequence is that there would have been no insured loss under the MII policy. And that's the reason there would be no need to make a claim. In fact, there would not be a claim under the MII policy because the net loss would be zero. So, in answer to my Lord Justice Popplewell's point, irrespective of the niceties of whether it's an owner's policy, for the purpose of clause 1.1, when one looks at the question of what the loss is and what the proximate cause of that loss is, i.e. what the dominant effective cause of that loss is, that inquiry doesn't depend upon whether the DAC constituted any particular type of policy. It depends upon the fact that, and for the purpose of the net loss, as you'll see, any insurance policy is taken into account for the purpose of, or any recoveries are taken into account for the purpose of the net loss. For the purpose of the causal inquiry, what matters is the fact that it was a forged document was the reason why it didn't respond, and the only reason why we would submit Oceanus suffered a loss. If the DAC had responded, there would have been no loss, no claim under the MII. In fact, there would be no claim under the war risk policy either, because the DAC would have paid out in advance. There'd be no subsequent non-payment by the war risk policy. And the fourth point in support of my submission, that the learned judge was wrong to treat the DAC as if it never existed in the context of her causal analysis, is that the judge's error meant that she effectively airbrushed the DAC out of the causal inquiry altogether. Even though it was a real document, and even though it had real causal impact, we would respectfully submit that that approach defies common sense. And common sense is particularly important in the context of a causation, an analysis of proximate causation. It's not simply a gut reaction, but it is a coherent approach to a causal problem. And in my respectful submission, if you asked any businessman, whether they're on the modern equivalent of the Clapham omnibus or otherwise, what the effective cause of Oceanus's loss was in this case, they would say the effective cause was the fact that the additional December cover on which they were relying while the vessel was in Ukraine turned out to be a forgery and didn't pay. That was the dominant and, we would submit, respectfully submit, effective cause of Oceanus's loss. So that's, we would respectfully submit, that deals with the second of the three fundamental errors we respectfully submit that the judge made in the context of the causation analysis. And that brings me to what we say is the third fundamental flaw. The third fundamental flaw in the judge's analysis is the fact that her errors in her approach meant that she failed to ask herself the correct question for the purposes of identifying the proximate cause of Oceanus's loss. And the correct question which we submit she should have asked is as follows. She should have asked herself, was the dominant or effective cause of Oceanus's insured loss the fact that the DAC did not respond to the casualty because it was a forgery, or the fact that the annual war risks policy did not respond to the casualty because of the breach of trading limits? Those are the only two potentially relevant causal inquiries to be had. And going back, I think, forgive me for this, going back to the point I was debating with my Lord Justice Popplewell a little while ago. My own friends could only recover under this policy, in my respectful submission, if they demonstrate that the loss they sustained was a result of the annual war risk policy not responding to the casualty because of a breach of trading limits. They have to show its loss was proximately caused by an insured peril, namely a breach of the trading limits. Unless they do so, in my respectful submission, they can't recover under this policy. But if the judge had asked herself the right question, then in our respectful submission, what she should and would have concluded is that the dominant and effective cause of Oceanus's loss was the failure of the DAC to respond to the casualty.
Does that submission involve it having to be shown that there was a sufficient causal connection between relying on the DAC and the vessel going to Ukrainian waters?
No. Simply,
how can reliance on the DAC be the proximate cause of the loss if reliance on the DAC was not a cause, possibly a proximate cause, of the vessel going into Ukrainian waters and suffering the casualty?
Well, when I said no, what I meant is that not to say that the points your lordships made are irrelevant, simply that what really matters is the scope of coverage. When I said the DAC was effectively the policy on which Oceanus was relying, what I meant is that when you contrast the DAC with the war risk policy, the DAC specifically provided cover while the vessel was in Ukrainian waters, whereas the annual war risk policy clearly didn't, because it had warranties and an exclusion when she was behind trading in breach of those warranties. Therefore, as Oceanus knew, that policy could never respond to a casualty if it was sustained during the vessel's voyage into Ukrainian waters. But the submission I'm making is the fact that the DAC policy was intended on its face as a matter of construction to respond to any casualty that was incurred or sustained by the vessel while she was in Ukrainian waters. It's a question of the scope of coverage. That's the key point. So if she'd asked herself the right question, was the dominant cause of Oceanus's loss the failure of the DAC to respond, given the fact that it was designed to cover the vessel when she was in Ukrainian waters, and given the fact that Oceanus was relying on the DAC cover in that context, clearly that's relevant to whether it's the dominant cause. And thirdly, as we know, the first thing that Oceanus did after the casualty was make a claim under the DAC. All of those factors are relevant to identifying what the dominant cause is, in my respectful submission. And as a matter of common sense and as a matter of analysis, the dominant cause of the loss that Oceanus sustained was the failure of the DAC on account of it being a forgery. And as we know, forgery is not an insured peril. This isn't a fidelity policy that insures the bank or Oceanus against any fraud on the part of its borrower. Only the losses caused by the named perils constitute a recoverable loss. And obviously, in this context of asking yourself the right question, if one is seeking to determine the causal potency of the fact that the DAC was a forged document, then the relevant counterfactual to take into account is what would have been the position had there been no forgery, had the DAC been a valid policy. And as I've sought to already articulate myself and by reference to my own friend Skeleton, had the DAC been a genuine document, not a forgery, it would have responded to the casualty, and as a consequence of that, Oceanus would have suffered no insured loss, and there would have been no claim either on the war risk policy or the MII policy. Now, even if, and given what my Lord Justice Popplewell has already articulated, even if you were to think to yourself, well, you can have more than one proximate cause. The non-payment under the war risk policy was also a cause of Oceanus's loss. Even if you were to reach the conclusion that there were two causes of Oceanus's loss, namely the inability to recover under the DAC because of the fact that it was a forged document, and the inability to recover under the the annual war risk policy because of the breach of trading limits. Even if you were to reach that conclusion, in my respectful submission, it's clear as a matter of common sense that the dominant and the effective cause of Oceanus's loss remained exclusively the failure of the DAC. It can't properly be said, in my respectful submission, that those causes were of equal efficacy. The failure of the DAC, the policy specifically designed to cover the vessel while she was in Ukrainian waters, the policy on which the Oceanus made the claim immediately the loss occurred, the failure of that policy completely eclipsed, in causal terms, any causal significance to be attached to the failure of the war risks policy. So for all those reasons, in our respectful submission, the learned judge was wrong to find that the proximate cause of the insured loss was the mine strike. That conclusion in itself goes nowhere. To recover under this policy, my own friends would have to show that the proximate cause of their insured loss was an insured peril, namely, for the purpose of this claim, a breach of the trading warranties. There's no respondent's notice that that should be the alternative basis of upholding the judgment. The judgment as it is, the finding of proximate cause, is wholly inadequate, and therefore the order should be set aside and the appeal allowed on the causation ground. So that's my first part of my argument. The second ground of appeal is what I may call the privity point. And as your lordships will know, the judge addressed the privity issues at paragraphs 56 to 76 of her judgment. That's pages 106 to 115 of the core bundle. And she recorded her decision. She followed the same pattern as she did in relation to causation, whereby she set out at some length, in some detail, the rival party submissions. And then at paragraphs 70 to 76, begins at page 112 through to 115, she set out her decision on privity. And if I may say so, in our respective position, one finds the core of her reasoning in paragraphs 73 through to 76. That's pages 113 to 115. And taking paragraph 73 first, the first sentence, the learned judge said, accordingly, the question for the court to determine is whether Oceanus knew, including Nelsonian blindness, and consented to or concurred in the breach of the trading warranties. Now, I don't quibble with that as being the relevant formulation of the question, providing that it's properly understood what consent or concurrence means in this context. And our submission on that was, I think she records it at page 1110, at paragraph 65. Our submission, the first sentence of paragraph 65, while the insurer accepts that some dicta on the meaning of privity in the context of section 39.5, pausing there, one of the important dicta, of course, is my Lord Justice Philip Popplewell below, where your Lordship said that privity means knowledge and consent, to the effect that it requires knowledge and concurrence or consent. So far as the contractual context of the insuring clause in the MII policy is concerned, passivity in the face of knowledge, given that it includes blind eye knowledge, is sufficient to render Oceanus privy. That was the submission I made. Of course, I didn't have the Michael at the time, but in my respectful submission, the Michael is of great assistance in identifying what is meant by the proviso in the insuring provision as to what can constitute being privy to, or having been privy to the existence or occurrence of an insured peril. And I've already shown you page 66. I'm not going to take you back to it, but you remember what Mr. Justice Carr says, namely that the consent can range between complicity to passivity, and in particular, if one becomes aware of the existence of a peril or a relevant occurrence, and saying nothing against it, that can constitute implied consent. And all that, in my respectful submission, is right and properly identifies the content of the proviso in clause 1.1.
Would it be right to say that passivity can only be treated as equivalent as implied concurrence or implied consent if the person is in a position to object or prevent it happening?
We make 2 points: object or prevent it happening.
You make 2
object.
Yes.
They're in a position to object. Yes.
And that's sufficient. You say.
That's fit. If they,
irrespective
yes.
of whether the objection would have any effect or not.
Yes, they have to object. I mean, our submission is the meaning of the privity proviso is this: that firstly, consent can range from active complicity to mere passive concurrence, and secondly, this goes to the point my Lord Justice Popplewell just made. If an insured knows, including through blind eye knowledge, that an insured peril exists or will occur, his consent will be implied if he says nothing against it. In general terms, I mean, obviously it's a fact-sensitive inquiry. That's, my lord, that's just a general proposition.
Does this arise on the facts of our case? Because here the owners, the insurer, get it right, the mortgagees consented explicitly to going to Ukrainian waters. They did not consent to going somewhere where the war risks cover where there would be no war risks cover, But it wasn't, I think, a case of passivity and silence.
My lord's quite right. On the facts of this case, again, we'll put it slightly differently to the way my lord has just put it, but Oceanus did consent to the breach of trading warranties, having been duped into believing that it had alternative war risk cover to cover the vessel while she was in Ukraine.
Yes.
And we'll look at the findings that the learned judge made, and the real question in this case is whether or not that consent was negated or vitiated by fraud. That's the question that lies at the very heart of this appeal. And obviously they'll come on to deal with that. But the reason I was articulating a submission as to what the content of consent can be, namely that it can range from active complicity to mere passive concurrence, and that if an insured knows, including blind eye knowledge, that an insured peril exists or will occur, their consent can be implied if he says nothing against it. The reason I made those submissions is for this purpose, namely that it's important. The important point to be derived from that is that consent in the context of privity is not to be equated with the formal requirements of an agreement in the classical contractual sense of the parties being ad idem. That is not, consent is not to be equated with a contractual agreement. Rather, the proviso calls for a fact-sensitive inquiry to determine whether or not the assured was content to allow the insured peril to exist or occur. And consent can be, unlike agreement for the purpose of contract, consent can be inferred from silence or from a failure to object in the face of knowledge. And why is that important? Well, it's important because in the circumstances of this case, we would submit that when one comes to consider the question as to whether or not fraud negates consent within the meaning of the proviso, parallels can usefully be drawn from criminal law and from tort law as to when, in those circumstances, consent is vitiated by fraud. They become persuasive given the fact that the nature of consent is not equivalent to a contractual agreement. And indeed, we would respectfully submit there can be no conceptual principled objection to having regard to tort law or criminal law for the purpose of understanding what consent entails, or the circumstances in which consent will be vitiated in the context of an insurance policy. And indeed, this court will be aware of the fact that only recently it had regard, I think, to the definition of damage in the Criminal Damage Act to help construe the meaning of the word damage in the context of a contract of employment, contract of insurance. I think my Lord Justice Popplewell was involved in that case, the Sky case, where criminal law was regarded as being relevant to determining the meaning of damage. But I'll come on to what help one gets from those other areas of the law. But of course, in due course, I'll be making a submission to the effect that collateral lies do not vitiate consent. That's ultimately going to be my submission. Now, the fundamental errors that the judge made in relation to the privity issue are to be found in paragraphs 76 and 75 of her judgment. Now, one goes to page 115, page 76, the penultimate sentence. Oceanus thought that the vessel would not be breaching the trading warranties because it thought that the additional cover had been obtained to permit the trading and to retain cover. Now, with the greatest respect to the learned deputy judge, that conclusion was, we would submit, plainly wrong and contrary to her earlier findings and what was common ground between the parties. It was common ground, and indeed the judge found, that Oceanus knew that if the vessel went to Ukraine, that would involve a breach of the trading warranties in the annual war risks policies. Indeed, that was the very reason why the additional December cover was required. Because Oceanus knew there'd be a breach of the trading warranties and knew, therefore, that the annual war risk policy would not, in any circumstances, respond if there was a casualty while the vessel was in Ukraine. The true position is that Oceanus knew full well that the additional cover did not cure the breach of the trading warranties or prevent the occurrence or existence of an insured peril. Rather, Oceanus knew of and consented to the existence and occurrence of the insured peril in the mistaken belief that it had additional protection which would protect it against the consequences or risks of that breach of warranty in the war risk policy. Now, as we know, that mistaken belief was induced by the fraud of the owners or charterers in presenting Oceanus with a fake just DAC. But the key question is whether or not that lie was of the type that negates consent, or whether it is a collateral lie that does not. Now, going back to the judgment, the other errors that the learned judge made in our respectful submission emerge from paragraph 75 on page 114. Having said in paragraph 74, found in paragraph 74, that Oceanus was duped, and it's clear on the evidence that it was on that basis and that basis alone that Oceanus agreed to allow the trading to take place. So there was consent in paragraph 74. But then in paragraph 75 she says, in my view, Oceanus never validly consented to or concurred in the breach of the trading warranties. Any consent or concurrence on the part of Oceanus was clearly obtained by fraud. In such circumstances, it would be wrong to say that Oceanus was privy to the breach of the trading warranties. Now, in our respectful submission, that conclusion was wrong, and moreover, it was not justified by the reasons that the judge gave. It was wrong because it failed to recognise the fact that the lie or the fraud was collateral to the existence or occurrence of the breach, and at no time...
Or collateral to the
breach of trading warranties, in the sense that Oceanus knew and was not deceived as to the fact that the trading warranties would definitely be breached.
But are we not concerned with whether it was collateral to the question to which privity is relevant, namely assent, consent, concurrence, whatever, non-objection to the vessel going to Ukraine? That's the activity which is said to be the activity which, in fact, was what gave rise to the existence or occurrence of the breach of the trading warranties.
But, my lord, the relevant peril is the existence of a breach of the trading warranties.
Right. And they don't exist unless and until the vessel enters Ukrainian waters for
Right.
purposes. Right. And what we're concerned with is whether, in consenting to the vessel going to Ukrainian waters, the mortgagees were deceived by something which was collateral to that consent,
Yes.
aren't we?
Yes.
And so it's a question of whether the deception in relation to the existence of the additional cover was collateral to the decision by Oceanus to consent to the vessel going to Ukrainian waters.
Quite.
It's not whether it was collateral to whether if she went, there would be a breach of the trading warranties.
Well,
It's a question of whether it's collateral to their decision to consent to the vessel going there.
well, my lord, yes, but only on the basis that by going there would be a breach of the trading warranties. And that's the key point. Because if the deception meant that Oceanus thought to itself that even though the vessel was going to Ukraine, there would not be a breach of the trading warranties, that would be a deception which would vitiate the consent. What we have here is a collateral lie, which meant that Oceanus knew full well that by going to Ukraine, by allowing the vessel to travel to Ukraine, there would be a breach of trading warranties. There would be the occurrence of an insured peril.
They only consented to that because of this, and we're looking at whether the consent to going to Ukraine, which was necessary in order for the existence of a breach of trading warranties, which is what they have to be privy to. The question is whether the consent to going to Ukraine was vitiated by fraud. And you say it's a fraud in relation to something which is collateral. As I understand, the point that's put against you is, no, it's a fraud in relation to something which was central to their consent to the vessel going there. Maybe collateral to the breach of the trading warranties, but it was central to their decision, and it was only the decision for the vessel to go there, which brings the privity question into existence, because you have to be privy to the occurrence or existence of the insured peril, and that insured peril, i.e. breach of trading warranties, doesn't occur or exist unless and until the vessel goes there. I think that's the point that's put against.
Quite, but there's no distinction between the existence and occurrence of the insured peril and the going to Ukraine. They are necessarily the same, unless there's a deception as to the fact that by going to Ukraine there won't be a breach of trading warranties. And there was no deception of that time. The only deception was as to what the consequences of the breach of trading warranties would be.
Well, is that right? Because if the DAC had been valid, then that would be an owner's policy, and there would be no breach of trading warranties.
Oh, my lord, there would be a breach of trading warranties. This is the key point. My lord, the war risk policy is an entirely separate policy to the additional December cover. What they could have done, and often happens, is that the owners could have approached their existing war risk underwriters and asked for a held cover clause, asked for a variation, pay additional premium, and go to the areas otherwise excluded. And in those circumstances, there would not be a breach of the trading warranties. Clearly.
If the DAC had been valid, why wouldn't that qualify as an owner's policy?
Well, my lord, it would. But it clearly would do, and there would still be a breach of the trading warranties in the separate annual war risk policy, which would not respond because of that breach. It's only there are two separate contracts. This is really important. There was always going to be a breach of the trading warranties within the annual war risk policy. That was never, ever going to respond to a casualty while the vessel was in Ukraine. Oceanus knew and accepted that risk. It was because of that risk that they took out, or insisted upon taking out, an additional policy in the form of the DAC, which was designed to provide cover precisely because the vessel was going to be in breach of the trading warranties, and as a consequence of that, the annual war risk policy would not respond.
Well, I know the insured peril is breach of trading warranties contained in any of the owner's policies, but if the owner had two concurrent policies, and there was a breach of trading warranties under one of them, and not a breach of trading warranties under the other, would there be an insured peril? Well, if there was cover under an owner's policy, would there be an insured peril?
Well, of course there would, if the non-recoverability under the relevant policy caused a loss within the meaning of clause 1.1.
So if the additional cover had been valid,
yes,
and those underwriters simply refused to pay, although they were liable, or become insolvent, then there could be recovery under the policy.
Under which policy?
Leave aside privity questions, but under the war risk policy, because it was in breach of those trading warranties.
You mean the war risk policy?
Yes.
Could there be
Let me just be clear. Assume war risk policy, trading in breach of trading warranties under that. Additional cover taken out with other underwriters, valid cover, those other underwriters simply refuse to pay. Valid claim under the MII policy?
Subject to the proviso, yes, but the proviso would prevent there being a valid claim. The reason being because Oceanus was privy to, in fact knew and consented to the fact that that war risk policy would not respond while the vessel was in Ukraine because of the breach of trading warranties, which was the very reason they took out the additional cover. The fact is, my lord, is what happened is that Oceanus put all its eggs into the December additional cover basket. That's what it decided to do, rightly or wrongly. It took the risk when it accepted and approved that DAC document, knowing full well that the underlying annual war risk policy would not respond in any circumstances to a casualty while the vessel was in Ukraine because of the breach of trading warranties.
So the difference between the held covered exercise, which you described earlier, i.e. getting an endorsement on the existing policy, and taking out the December additional cover with other underwriters, becomes fundamental on your approach.
Well, it can be fundamental to the existence of privity in this sense, that had the lie been, we have spoken to the underwriters and they have agreed to hold us covered and not treat us as being in breach of trading warranties. If that had been the lie, and Oceanus had agreed to the voyage to Ukraine going ahead on that basis, Oceanus would not be privy to a breach of the trading, would not be privy to the existence or occurrence of a peril because it would not know or consented to the breach of any trading warranties.
Yes, and that's why you say it is. My lord's right in saying it's fundamental.
It is, well, yes,
It's fundamental, and
the nature of the lie is fundamental, and it can because if the lie relates to whether or not there will be a breach of trading warranties, then it will vitiate privity. Because Oceanus doesn't know or consent to the fact that there will be a breach of trading warranties. But if the lie relates to the consequences or the mitigation of the consequences of there being a breach of trading warranties and the non-response of the war risk policy, because they've got some mitigating collateral benefit in the form of an additional policy, then that consent to the breach of trading warranties will not be vitiated. Because the lie only relates to the consequences of the breach, and there's no deception on Oceanus as to whether or not the breach of trading warranties will occur. They know perfectly well it will occur. They know that the war risk policy will not respond, and that's the very reason why they insist on a separate policy.
I think what you just said is this. Can I just check that if the lie is whether there will be a breach of the trading warranty under the existing policy, that will vitiate consent, but it will not do so if the lie is that the owners have got cover under a different policy.
Yeah, you need to add on that because the assured still knows and is not deceived as to the existence of the breach of trading warranties in the underlying war risk policy.
Yes.
Yeah, but that's right, my lord. That's my submission.
would it have made any difference to Oceanus if they'd been presented with, on the one hand, an endorsement of the war risk policy, or on the other, cover from different underwriters?
Well, it would have made a difference in the sense that they wouldn't have known, wouldn't have been aware of the fact there was going to be a breach of a trading warranty, or the occurrence of a
But in
peril.
commercial terms, it would. I don't think, from the correspondence I've looked at, they were actually specific about what form the war risk cover was going to be in that they were insisting on. I know previously they'd had the November cover note, which was with alternative underwriters, but if Mr. Yugater had said, well, we've got an endorsement of the war risks policy, Oceanus would have been just as happy with that, wouldn't they, from a commercial point of view?
My lord, one doesn't know, but potentially yes. Accept that. This is one of these cases that I mean, I think the Americans take credit for it through Oliver Wendell Holmes, but actually it's an English Winterbottom Right is where it came first mentioned, which is that hard cases can sometimes make bad law. And what's odd about this case is that if Oceanus was kept completely in the dark and knew nothing about the trades to Ukraine or the existence of an additional policy and the like, then they would have been able to recover under the MII policy on the basis that the annual war risk policy did not respond because of the breach of trading warranties, which they were unaware. Likewise, had the lie been there won't be a breach of trading warranties, they wouldn't have been privy to the existence or occurrence of a peril, and indeed would have been just as happy with an endorsement, as my Lord has articulated. But none of those facts actually happened. And not only that, it is important to recognise that this bank, or this lender, Oceanus, was in the position it was because it had made the most dreadful of bargains that it could possibly make when it lent this money to these owners. Not a penny was repaid from day one. The loan was a complete and utter disaster. They never got a penny back. She was in default immediately. And that was the reason why Oceanus was so proactive. That was why Oceanus was engaged to the level it was in what the activities its non-paying borrower was up to.
Well, that's good prejudicial stuff, but does that help us on whether the lie is collateral?
Well, no, it doesn't, but it goes to my own friend, sorry, my Lord Justice Popplewell's point, which is he said, well, in commercial terms, they would have been just as happy with a endorsement as they would have been with an additional policy. And why does it really matter that one, they're privy and the other, I think that was the point that we put against me. And I'm trying
that arises it being a given that they're deeply involved in circumstances in which they might...
Well, that's quite true, but that, to my point, doesn't answer everything. It answers perhaps the point about why they were so engaged, but they didn't ask for an endorsement, they asked for the additional policy as they got in November.
Well, I'm not sure they did ask for that. I think, as far as I've read the correspondence, they just say we want to see some war risk cover.
Well, they wanted to see the war risk cover, which was going to cover the vessel while she was in Ukraine, which they understood to be separate from the annual war risk policy.
You may be right about that, but I've certainly not seen anything to that effect. Having looked at the correspondence we got in the bundle, I don't think there's anything in that, but do tell me if I'm wrong.
Well, let me just...
It indicates that they were requiring it to be in the same form as the November cover.
Well, they were asking for the cover note. I can't put it too high. I mean, in the sense that they were asking for the insurance policy, but I accept that in reality they could have been provided with a held covered endorsement. I accept that, and I accept that in commercial terms they might well have been happy with that. And I also accept that if they didn't know there was going to be a breach of the trading warranties, they wouldn't be privy to the breach of trading warranties. But that simply isn't what happened. And it is different, this case, because that's not what happened. What happened here was that they did know that the annual war risk policy was not going to respond, and they did know the reason for that, namely the fact that there was a breach of trading warranties. They took that risk. That's the essence of it. They took that risk, and it turned out that the DAC was forged, and that was not a risk that my clients insured against. Now, going back, if we made to paragraph 75, where the learned judge, in the first two sentences, gives her conclusion, namely, they never validly consented and it was vitiated by fraud, in general terms. She then gives some reasons for that conclusion. The first reason she gives is that says it did not know the true position as regards the war insurance. Well, sorry, the war risks insurance. Now, that statement is of utmost generality, but it's
Says
not.
Michael, where are you in the
I
judgment now?
beg your pardon, my Lord. I'm going back to paragraph 75,
Yeah,
page 114 of the core bundle.
I'm with you now. Thank you.
And what I'm examining is the reasons given by the learned judge to support her conclusion that there was no valid consent. And the first reason she gives is it did not know, namely Oceanus, did not know the true position as regards the war risks insurance. Now, on that, we would submit that that statement obviously is general, and it's not clear exactly what she's referring to. But the key point is that Oceanus did know the true position as regards the breach of trading warranties in the war risk policy. They always knew that a voyage to Ukraine would amount to a breach of the trading warranties in the war risk policy, and that policy would not respond. That was always something they knew, and which they were never deceived about. Now, the second reason that the learned judge gives in the next paragraph is that Oceanus had no reason to be suspicious of the cover note provided in circumstances where a valid cover note had been provided for a similar voyage a month earlier. There was no turning a blind eye. Mr. Muggleson stated in evidence Oceanus relied upon the cover note that was provided and the sign-off by Miss Trine that everything is in order, no need to hold back the vessel. Now, of course, that's true, but that doesn't support the conclusion that Oceanus was not privy to the breach of trading warranties. And the reason, when the learned judge says Oceanus relied upon the cover note that was provided, it did rely upon the cover note. But the reason it relied upon the cover note rather than the war risk policy was because it knew full well that the war risk policy would not respond to the casualty while the vessel was in Ukrainian waters. Oceanus was deceived, but it was deceived into thinking that it was protected against the consequences of the occurrence of the insured peril. But it wasn't deceived as to the existence of the insured peril itself. And then the third reason she gives, she says, if Lyra Mare's if Lyra Mare or the charterer's lie had been to present a false copy of the war risk policy with the trading limits misstated, or had been to say that the war risk policy had been amended so to permit voyages to Ukraine, the answer would be clear. Oceanus would not have known and consented to or concurred in the breach of the trading warranties. And then she says there is, in my view, no reason why it should make a difference that Lyra Mare's or the charterer's lie was that the voyage was covered under a separate policy. This is a point that reflects the point that I discussed with my Lord Justice Males. Now, there is, I will respectfully submit, a fundamental difference between the different lies that are being postulated by the judge in those two contrasting sentences. If the lie had been to the effect, as identified in the two examples that she gives, that the voyage to Ukraine would not involve a breach of the trading warranties, then obviously Oceanus would not have known or consented to the breach of trading warranties and the existence of a peril, because it would have been deceived into believing that there was no breach of warranty. And as a consequence, obviously, it couldn't concur in the existence of such a breach, given that it didn't know one was going to occur. But by contrast, and this is why there is a difference between what the learned judge postulates, as I sought to illustrate in my answer to Lord Justice Males' question, if by contrast, as happened in this case, the lie is to the effect that a separate policy has been arranged precisely because the voyage will involve a breach of warranty and the occurrence of a peril, that lie only relates to the consequences of the insured peril and not the occurrence of the peril itself. In other words, it is collateral. And it's collateral because the owner or the Oceanus is not deceived as to the existence or occurrence of an insured peril. It knows that is going to take place. all the lie relates to is whether or not Oceanus has adequate protection as a consequence of the fact that the war risk policy will not respond. Now, another way of looking at this is to ask oneself, what is the purpose of the proviso? What is it seeking to achieve contractually or commercially? And on that, my lords, my submission would be that the effect of the proviso is that the MII is not intended to respond if the assured is aware of and accepts the risk that an owner's primary policy will not respond to a casualty as a result of a named peril. So, given that Oceanus, in this case, consented to the breach of trading warranties, but on the basis that it thought it had consequential protection in the form of the Defendant additional cover, it was still willing to run the risk that the annual war risk policy would not respond to the claim, because it knew that was going to be the consequence of that voyage. And having consented to the fact that the war risk policy would not respond to a casualty while the vessel was in Ukrainian waters, albeit on the basis of mistaken belief as to the existence of alternative cover, it can't, in our respectful submission, thereafter claim on the policy, on the MII policy, on the basis that the war risks policy should have covered that loss. And the reason why it can't do that is because Oceanus knew all along that that policy would not respond to that loss, that casualty. And that was the very reason why it took out or insisted upon the DAC being taken out. Where the judgment goes is that the very important question as to what category of lies will vitiate consent and what category of lies do not vitiate consent was not properly grappled with by the learned judge.
Is it really that question, or is it, as you say, a different point, which is your collaterality point? It's not the sort of nature of the lie, it's what it goes to.
I think that's probably right, my lord, yes. When I meant nature, I meant to refer to the collateral aspect, or whether it goes to the consequences of the act rather than the act itself. But yes, my lordship's right. But I suppose the starting point is this, that in our respectful submission, it is clear that not all lies or all unfulfilled conditions will vitiate or negate consent. Can't be the case at all. I mean, the way the learned judge below approaches it is essentially to say, well, agreement was induced by fraud, therefore it's not valid. But it can't be right that all lies, all fraud will vitiate or negate consent. It may do in terms of a contractual agreement, but consent is rather different. And we've given some examples in our skeleton whereby a lie will not vitiate consent, even if the lie is regarded by the representee as fundamental. If it's collateral, it will not vitiate consent. And we've given some examples in the shipping context. For example, if an assured were to agree to a vessel trading in breach of warranties on the basis of a lie or an unfulfilled condition that the vessel would say spoof its AIS, its automatic identification system, in the hope therefore it wouldn't be identified as being in breach of trading warranties, even if that promise to spoof the AIS is not complied with, it couldn't be said, in my respectful submission, that the existence of that lie thereby negated the assured's being privy to the existence or occurrence of the breach. And the reason why that's so is because the assured is not deceived as to the existence of the breach of trading warranties itself. The relevant falsity, and this picks up the point perhaps my Lord Justice Newey captured, the relevant falsity is collateral to the breach and only relates to mitigating its consequences. And we submit that the same analysis is true of the deception perpetrated on Oceanus in this case. It was fraudulently deceived into believing that it had alternative cover to protect it against the consequences of the breach of the trading warranties in the annual war risk policy. But the falsity only related to the consequences of the breach of trading warranties, not to the existence or occurrence of that breach. And therefore the lie is collateral, and therefore the lie, in my respectful submission, doesn't prevent the assured from being privy to the existence or occurrence of the peril. And the reason for that, in commercial terms, is because it was relying upon the DAC. That to pick up my Lord Justice Popplewell's commercial approach, the reality is that what Oceanus did was that it realised the annual war risk policy would not respond, but nonetheless decided to allow the voyage to go ahead on the basis it had the DAC as its cover for the consequences of trading to Ukraine. It just so happens that that cover failed to pay, but it failed to pay for a reason which my clients didn't provide cover, namely forgeries. We only provide cover for the named perils in the MII policy, not for general infidelity on the part of owners. Now, another analogy we would submit that's potentially relevant here is that this approach is not dissimilar in terms of analysis to collateral lies that are told in support of a valid insurance claim. Under an insurance policy, the Supreme Court has made it clear that collateral lies do not make a valid claim fraudulent. And the reason for that is because they don't affect the fact that the insurer has a valid claim which it's obliged to pay. And in the same sense, in this case, the lie that was told to Oceanus was collateral in the sense that it was irrelevant to the question whether the voyage to Ukraine would breach trading warranties.
But that isn't concerned with consent or vitiating consent, is it?
No.
Collateral devices. I mean, we're not really in the same area at all, are we?
Well, it's an analogy, and not a very complete one. What I was making the point about was the fact that even if a collateral lie could be said to have material influence on the underwriter's decision to pay, if in fact it's irrelevant to the validity of the claim, it doesn't turn the claim into a fraudulent claim, even though it was an inducement. That's the point I was making. So there's an element of consent, but the key point I was making is that a lie, the key point I'm making is this, I suppose, is that what that line of authority demonstrates is that lies that relate to the exaggeration of a claim are different to lies that are simply collateral to the claim. And there may be subtle differences. I just ask you to bear that in mind when you're considering, well, Bailey's got this narrow point, so narrow here. He's saying, if it's a separate policy, it makes all the difference. When it's a whole covered slip, these kind of points, is there really any difference? And I'm saying that the nature of the lie can make a fundamental difference, and that's to some extent demonstrated by the fact that a collateral lie, a devious device, which is actually irrelevant to the substance of the claim, doesn't prevent a claim from being a valid claim, whereas a lie which exaggerates the claim does do. And that's a difference, and I'm suggesting that's an analogous difference that we have here. But
looking at the matter broadly, would it be right that what the mortgagee wanted throughout its dealings with this insured was a package of insurance protection consisting of both the underlying war risks cover and the MII cover, and that in relying on the DAC, it was not intending to jettison the protection it had under the MII cover and look exclusively to the DAC for anything that might happen on this voyage. It still wanted to have its full package of protection available to it. And
yes, I think maybe there's
a bear on whether this was collateral or not.
Well, Lord, I think the way in which your lordship postulated the point is that they were relying upon the MII policy. The key point
Well,
is
they were not abandoning reliance
No.
on the MII.
no, they weren't. They always relied upon the MII policy, and they relied initially upon the war risk policy. But then, when they discovered that she was going to Ukraine, they insisted on a separate policy to ensure that they were covered, and they were still relying upon the MII. So, for example, if the DAC, if I may call it that, hadn't responded because of a breach of the duty of good faith, or because it was avoided for some non-disclosure, then my clients would have been liable under the MII policy to pay.
But if you're right, and if before giving their consent to go to Ukraine, they had looked up the MII policy, they would have seen, oh well, going to Ukraine is a breach of the trading warranty under the underlying annual war risks policy. So the MII policy won't pay if anything goes wrong. Therefore, we're looking exclusively to the DAC.
Well, no. The trading warranties are in the underlying annual war risk policy.
Yes, and your point is that they knew that going to Ukraine would breach those.
Yes. So the annual war risk policy would not
for the
reply.
for the reasons you gave earlier, having a separate cover for this particular voyage would not cure that breach.
Quite. But it would quite. So, but I think my lord has probably slightly got this slightly wrong, if I may say so.
Very possibly.
I'm trying to only in this sense that the trading warranties were in the underlying annual war risk policy. The MII policy responds if there is a loss as a result of a breach of the trading warranties. That's what it's designed to do. The problem is that the assured was privy to that, and that brings into play the proviso. Therefore, it took out the DAC. Now, had the DAC failed, not because it was a forgery, but because it was avoided, or because there had been non-disclosure, or for any of the other reasons identified in Clause 2, then the MII policy would have responded.
Because an insured peril would have occurred in relation to that policy.
Exactly. An insured peril would have occurred in relation to the DAC.
And therefore, despite the wording of 2.1.3 that I put to you earlier about any owner's policy, you do accept that just because the war risk policy wouldn't have responded, wouldn't prevent you being liable in the MII policy.
Sorry if I said that I was wrong. If I think it's in our skeleton, so I'm not, that we recognise that if the DAC did not respond for any of the reasons set out in Clause 2...
It would have been an owner's policy. It would have responded by reason of an insured peril in relation to that, and it would have been irrelevant that there was another owner's policy, namely the war risks.
Quite. And for obvious reasons, that everybody knew that was never going to respond anyway because of the breach of trading limits. The policy that was providing prima facie cover in those circumstances would be the DAC. And we've had the debate about the fact that it was a fraudulent policy, and therefore whether in December, before the underwriters had taken that point, it's be ignored. And we've gone through that already in a different context. But putting that to one side, if the DAC had been a valid policy, or had the reason it not responded being any of the reasons identified in Clause 2, then we would be liable. So I think that was a slight difference between...
Yes, I see.
But the only reason we're not liable here, why we're not liable, is because forgery is not an insured peril. In fact, there's a warranty that in this policy which puts the burden on Oceanus essentially to ensure that valid insurance is in place throughout. That's the risk they carry. But even if that's not right, the key point is that forgery of a policy is not an insured peril. And moreover, this is not a fidelity policy. It's not a policy that protects the lender, Oceanus, against any kind of misconduct on the part of the borrower. It's not as broad as that. It's much narrower cover. It only costs $1,800 a year. It's a narrow contingent cover on named peril basis. The annual additional cover, the 1 week cover to go to Ukraine costs $37,000. The that these are completely different beasts. I know you can't, the amount of premium isn't going to affect what the meaning of the words say, and obviously they don't help in that context. But in terms of the nature of the risk that's being assumed, the contingent MII policy is very much narrower in scope than a primary policy on property, such as a war risk policy.
Can I take you back to the more general question of
Yes.
what you mean by collateral? If the question we're concerned with is whether, in our case, positive consent for the vessel going to Ukraine is vitiated by some deception, why does it have to be a deception about the war risk policy? Why isn't it enough that it's any deception which in reality prevents that consent being in reality consent? In other words, why do you say that if the deception was that they were going to spoof the AIS, that wouldn't work? Why is that? Why does that not undermine consent?
Well, that's a very good question, my Lord. I'll do my best to answer it. The reason being is because the deceit in relation to the ASI doesn't deceive the lender in any sense as to whether or not there will be a breach of trading warranties.
But so what? What I'm putting to you is, if what the assured has to be privy to is the existence of the insured peril.
Yes.
And if the insured peril only exists if the vessel trades in breach of trading warranties, and if the vessel doesn't trade in breach of trading warranties unless and until she actually goes to Ukraine, and if, as I think is part of your argument, the relevant consent, assent, whatever it may be in this case, was to the vessel going to Ukrainian waters, why isn't anything which vitiates the consent to the physical voyage something which undermines consent? I think that's what I'm trying to get at. Why are only some things?
Well, because the consent is actually not just about going to Ukraine. It's more precise than that. The consent has to relate to the existence and occurrence of the peril.
Yeah, but the peril doesn't exist unless and until it goes to Ukraine.
True.
True.
But it's the existence of the breach. It's the fact that the going to Ukraine constitutes a breach of the trading warranties. That is.
If she goes to Ukraine, they know there will be a breach of the trading warranties.
Yes.
They consent to her going to Ukraine.
Yes.
And what we're concerned with is whether that consent is consent which is vitiated for privity purposes.
Exactly. But the consent.
Why is that consent, which simply has to be consent to her going to Ukraine, why does that have to be vitiated by something that relates to the war risk policy?
It has to be vitiated by something that means that the assured doesn't understand that by going to Ukraine there'll be a breach of the trading warranties.
I mean, I do wonder whether this vitiation word is just a red herring. I mean, on your case, as I understand it, policy says that the insured peril has to occur without the privity of the assured. The assured peril here is breach of the trading warranties of the main policy. So the question is, was there consent to breach of the trading warranties in the main policy?
Quite.
And you say that's what there has to be consent to. Vitiation just doesn't come into it. There was consent to something different.
There was consent to going to Ukraine in circumstances where it was known that that would inevitably constitute a breach of trading warranties. And the lie that was told in relation to having a separate policy to cover against the consequences of that was wholly collateral, in the sense that it didn't in any way prevent the Oceanus from knowing full well that by going to Ukraine there'd be a breach of the trading warranties. That's what is meant by collateral. A lie that doesn't in any way deceive Oceanus as to its knowledge as to the existence of the peril, namely the breach of trading warranties, doesn't vitiate it or doesn't negate it. I can use that word. That's my submission. And to try and demonstrate, there are some, and we submit the distinction between collateral lies of the sort I've identified and those lies that do negate consent is, we submit, sound as a matter of analysis and a matter of principle in any event. But there are some helpful, compatible judicial utterances in the criminal tortious areas of the law, which we submit are at least helpful in this context. And the three cases, if I may, I'd like just to show your lordships. The first is a case called R versus Lawrence, which is in bundle 2 of the authorities bundle, at page 413. If we go to the head note, basically what happened in that case was that a complainant had agreed to have sex on the basis of a lie on the part of the other party that he'd had a vasectomy. That was a lie. It was the only basis on which she agreed to have sex with him, and as a consequence, he was convicted of rape on the basis that her consent had been vitiated by his lie. He appealed against conviction on the basis that the complainant's consent had not been vitiated by his deception. I'm just reading from the head note, and the appeal was allowed. And as far as relevant passages I ask you to consider are the prosecution's submissions are summarised at paragraph 12 on page 417. And in particular, 12.2, there was no material difference between the position of the complainants in Assange and R, both of whom sought to avoid the risk of pregnancy, and this case, where consent to sexual intercourse with the defendant was conditional upon his infertility and thus no risk of pregnancy. That was the prosecution's case. And paragraphs 13 and 14 are instructive. The judge ruled that if the jury accepted the evidence of the complainant, the defendant's deceit of his infertility was capable of negating her consent to having sexual intercourse with him. And then, if paragraph 14 is particularly helpful, possibly, the judge concluded that the distinction which the defendant sought to draw between the consequences of the act of intercourse and the nature of the act itself was artificial. And of course, you might hear similar submissions from my learned friend on my argument. But as we know, the appeal in this case was allowed, and the Court of Appeal concluded that the deception was not capable of negating her consent. And one sees, as far as it's helpful, a relevant discussion of that in paragraphs 34 to 37 on page 422. Returning to the facts of this case, the jury concluded that the complainant relied on the defendant's deception regarding a vasectomy, and that she would not have consented to unprotected sexual intercourse had she thought him to be fertile. However, the but-for test is insufficient of itself to vitiate consent. There may be many circumstances in which a complainant is deceived about a matter which is central to her choice to have sexual intercourse. Monica was an example, but they can be multiplied. Lies concerning marital status or being in a committed relationship, lies about political or religious views, lies about status, employment or wealth are such examples. A bigamist does not commit rape or sexual assault upon his or her spouse, despite the fundamental deception involved. The consent of the deceived spouse, even if it would not have been forthcoming had the truth been known, does not vitiate the consent for the purposes of sexual offending. Neither is the consent of a sex worker vitiated if the client never intends to pay. So that's more of a contraction example where if a sex worker says they will have sex with a client in return for £200, but the client never intends to pay, or he uses counterfeit money to pay, this is R versus Lineker, there is no negation of the consent. What's the reason? The reason for all those examples that are given in paragraph 34, in my respectful submission, they are all good examples of collateral lies. And the reason they don't vitiate or negate consent is because they don't affect the fact that the act itself is going to take place, which is being consented to. That is brought out slightly more clearly in paragraph 37, where the court says, unlike the woman in Assange, or F, the complainant agreed to sexual intercourse with the defendant without imposing any physical restrictions. She agreed both to penetration of her vagina and to ejaculation without the protection of a condom. In so doing, she was deceived about the nature or quality of the ejaculate, and therefore of the risks and possible consequences of unprotected intercourse. The deception was one which related not to the physical performance of the sexual act, but to the risks or consequences associated with it.
Well, paragraph 35 is where the court defines the question. How would you transpose that to the facts of this case? The question is whether a lie as to insurance cover is so closely connected to what that it is capable of negating consent.
It's whether it's so closely connected to the existence of a breach of the trading warranties.
It's surely the equivalent of the sexual act in this case is the vessel going to Ukraine. That's what's consented to, and now we're looking at whether something undermines that consent.
Well, we know it has to be consent because privity. We're talking about the peril, and the peril is the breach of the trading warranty.
Yeah, surely the equivalent, translated into our context, the equivalent of the sexual act here is the vessel going to Ukraine. In that case, the question was whether there was consent to the sexual act and whether deception was sufficiently closely connected to it to mean there was no consent. Here, the actual act is agreeing to send the vessel to Ukraine. We have to be concerned with whether the lie is sufficiently closely connected with the consent to the vessel going to Ukraine.
Well, my lord, going to Ukraine because it is a breach of trading warranties. That's all I'm asking you to take into account. It's not, isn't it? It's because
can one get to agreement on going to Ukraine in breach of the trading warranties?
Thank you. Yes, going to Ukraine in breach of the trading warranties is the act, quite. And we would submit that the lie here related to the consequences of so doing, because the consequences of going to Ukraine in breach of trading warranties meant that the annual war risk policy would not respond in any circumstances. And the purpose of the DAC was to mitigate against the consequences of that. And the lie, therefore, was collateral because it only related to the adequacy of the consequential protection rather than to the existence of the breach of warranty itself. The tort cases actually articulate the point in a more precise way. They are in the same bundle actually they're not, I beg your pardon. They're in, this first one is in volume 1 of the authorities bundle, at tab 8. And this is a case cited in the Court of Appeal in California, and it's a case concerning an alleged battery, a tort of battery. And the relevant passages are page 121 of the bundle, on the right-hand column. We have concluded that plaintiffs can state a cognizable cause of action for battery. A battery is a violation of an individual's interest in freedom from unintentional, unlawful, harmful, or offensive unconsented contracts with his or her person. The element of lack of consent to the particular contact is an essential element of battery. And over the page, for the purpose of the present proceedings, the critical question is whether the plaintiffs allege or could allege facts sufficient to show that there was an absence of informed consent by the plaintiffs to the particular offensive nature of the contract alleged. And then there's reference to the restatement of second of torts, section 55, which does discuss the fact there are some lies that vitiate consent and some lies that don't. And picking up the analysis at the bottom of page 122 in the left-hand column, the same rule is stated in Prosser on torts, section 18, mistake, fraud and duress. A physician may be liable for inducing an innocent girl to submit to indecent liberties when he knows that she is ignorant of the fact that they are unnecessary for medical treatment. Apparently, however, the mistake must extend to the essential character of the act itself, which is to say, that which makes it harmful or offensive, rather than to some collateral matter which merely operates as an inducement. Thus, consent to intercourse is still consent, although it is in return for counterfeit money. The woman has no cause of action for battery when she subsequently decides that she has been raped. So pausing there, the example being postulated is that a sex worker agrees, consents to have sex with a client on the basis that he pays her, or it could be the other way around, they pay the sex worker, let's say £100. And that's, from the sex worker's perspective, that £100 is absolutely essential to the deal. She wouldn't be having sex with this client unless she was being paid. But he pays her in counterfeit notes, a forged £50 notes. So, and he deceives her into thinking she's been paid. Why? Why is her consent not negated in those circumstances? And the reason is because the lie is only collateral to the act itself. Notwithstanding the fact that she is deceived in thinking she's been paid, she is nonetheless consenting to the physical act of intercourse, because the lie is only collateral and doesn't affect her agreement. And that is we would submit, a very powerful analogy, which is to assist your lordships in this case. Anyway, going back to this decision, the text continues. An analogous vitiation of consent is recognised in Fleming on torts, section 78, defences to intentional torts, consent, reality of consent. There it is stated that some misapprehensions also vitiate consent. Deceit as to the real nature of the defendant's conduct clearly does, as when it was held to be a rape for a choirmaster to seduce a young pupil ignorant of the facts of life, under the pretence that this would improve her voice. On the other hand, a deceit relating to a wholly collateral matter, which operates merely as an inducement, does not destroy the reality of consent, e.g. a woman who lives with her paramour under a false promise that he would marry her cannot maintain that every act of intercourse is an assault. So that case helps in identifying what is meant by a collateral lie. And there's one further case I'd like to show you, lordships, same bundle at tab 12 at page 189.
Is that going to take a few moments, or is it convenient to take it before we break?
If we could just...
Yes.
Because it's the last case I want to show you on privity, then we can have a clean start on fortuity.
Yes.
It's at page 189, just taking up the summary on the left-hand column, the first paragraph. The complainant alleged that the plaintiff was induced to accept administration of the drug Pitokin during childbirth upon her physician's intentional misrep as the intended effect of the drug. The complainant alleged that the physician told her it was needed to prevent infection when in reality the drug is used to induce labour. The facts don't particularly matter, but I would ask you to bear in mind 190 on the right-hand column, the first full paragraph, where it said, in addition, it's alleged that when the physician instructed the plaintiff to accept the administration of Pitokin, he knowingly and intentionally misrepresented to her that Pitokin was necessary to prevent infection. Had the plaintiff known the true nature and purpose of the drug, she alleges she would not have consented to its use. Therefore, consent was fraudulently obtained and not effective as an offence. So that was her case. In other words, it was essential to her decision. Nonetheless, the court, and perhaps I was a bit over-optimistic, but the relevant parts of the analysis are on page 191, starting on the left-hand column, and there's a reference to Rains, and then little 2. There's the use of the phrase essential character of the act that the Rains court was referring to as a distinction made in legal texts as to the varying kinds of misrepresentations which can give rise to mistaken consent. To vitiate consent, the mistake must extend to the essential character of the act itself, which is to say that which makes it harmful or offensive, rather than some collateral matter which merely operates as an inducement. The illuminating example given in the text is that of the seduction of a voice pupil by a choir master on representation that prove her voice, compared to the seduction of a woman by a false promise of marriage. In the first instance, the physical contact is a battery because the essential character of the act has been misrepresented, is not an exercise for voice improvement for the personal gratification of the seducer. In the second case, both parties know the essential character of the act, and the inducement which gains the consent relates to a collateral matter, marriage. Now, pausing there, both parties, Oceanus and the owners, both knew the essential effect of going to Ukraine was that there would be a breach of the trading warranties. The inducement that Oceanus was given to get that consent was the promise of a separate, consequential, collateral contract which will protect against the consequences of going to Ukraine. But that deceit as to the existence of that consequential benefit did not mean that in any sense that Oceanus was not consenting to the voyage to Ukraine in breach of trading warranties. Those essentially are my submissions on the privity point. It believed it would be protected against the consequences of what it agreed to do. It was not, but that was not a risk that my clients insured. That was a risk which they voluntarily adopted for themselves. Oceanus knew all along that the voyage to Ukraine would breach the trading warranties in the annual war risk policy. Because it knew that, it was privy to that peril, and for that reason there's no liability under the MII policy. And Lord, I'm sorry if I have gone slightly over one, but those are my submissions on privity, which means I have fortuity to go, which I hope I can take relatively shortly after the short adjournment.
Thank you very much. So, took up.
Court rises able.